I don't know. Let me think about it. Okay. Well, we're here on what is today anyway? The 9th? 9th? Okay. February 9th, 1999. We're going to just talk about a whole bunch of miscellaneous issues, dealing mostly with taxes, I think. The Franchise Tax Board, IRS. Whenever you talk about the Franchise Tax Board, you end up talking about the IRS because the Franchise Tax Board runs to the IRS to get their support for what they want to do. One case in particular, anybody here who's used the Irwin Schiff zero tax return, you know, will have a problem with the FTB nowadays. Although, after I tell you about this, I'll tell you how to do the IRS, or not the IRS, but the Franchise Tax Board, and not have a problem while still doing the zero return, which is probably what you'd like. So I'll tell you how to do it where they won't give you a headache about what you do. At least not immediately. They'll get you your refund first instead of holding on to it and hit you with a penalty like they do. Okay, we have one gentleman here who filed a zero return for the state of California, and presumably also for the IRS. And many of you may or may not know, but the state of California's return is based upon and cannot be filed without, if it has any kind of complication to it, the federal return. Unless it's something very, very simple, like what we'd call a 1040 easy and a 540 easy, you really have to attach a federal tax return to it, and they pull all the information off of the federal, and all they do is make adjustments to the federal numbers, and there they've got the state tax return. And so now comes the question, if you have since the law requires, and since all the statutes, the revenue and taxation statutes, are merely modifications of the federal law, and you have to get your information off of your federal form to put on the state form. If your federal form shows 0, what do you have to put on your state form for income? You've got to put 0, okay? That's following the law. If you put something else, you're not following the law. You're not following what it says. Now, let me show you how this works, how the state's doing it right now. What was done right here was, here's I'll kind of hide the name. He probably doesn't care, but anyway, this is the form, see? And what he did was he put zeros, 0 for wages, okay, and 0 all the way down for everything else. And on the second page, let me get a second page. Yeah, on the second page, he's got zeros for everything. He must not have paid anything because he's not asking for any refund either. Okay, so we have zeros for everything. The state disagreed. And it says, and this is a very common letter, by the way, when they think that you're filing a zero return, they say, we have received your California income tax return forms for the years shown above, and this, what year do they show above? Oh, 1996. Okay, and have determined that the form constitutes a frivolous state income tax return. California Revenue and Taxation Code, R&TC, Section 19179, provides that a penalty of $500 shall be imposed for filing a frivolous income tax return. Now, all of you who have gone and come here enough, what's the first thing you want to do when they quote you a code section? Look it up and see what it says, right? And what's the second thing you want to do? Read it. Well, read it. That's part of looking up and seeing what it says. But what's the second thing you want to do besides reading it?
Regulations.
Yeah, see if it has enforcing regulations, right? If it doesn't have enforcing regulations, who cares if there's a code section? So we got 19179. Now, I don't know what the answer to the question is, but I'll find out here shortly. 19179. Ho, ho, ho. How about that? Here, you might get a close-up of here. Here's 19179, at least where it's supposed to be, if it had enforcing regulations. But we find that it goes from 19141.6 to 19253. 19179 has no enforcing regulations. So much for the $500 penalty. Okay? But now, oh, you can get this at any good law library, in particular the one over here at the Maple, on Maple, the Torrance Court. It's called Barclay's, it's the master index of Barclay's Official California Code of Regulations. And what it has every one, it's like a brown book, it's about that thick, and it has every one of the titles in it, and each title section, in fact, I copied that to kind of give you explanation about how it works and all that stuff. But it tells you that if there are any, let's see what it says here. This table lists all the California statutes cited in the authority and the reference notes to the sections in the California Code of Regulations. For each statute section number, all related California regulations are provided by title and section number. The listing of the statutes is alphabetical by statutory code. Within each statutory code, the listing is by statute section number arranged in numerical order. The statutory references may include et sequa and in ranges in addition to whole numbers. When the statute section number is repeated and followed by et sequa and or repeated at the beginning of range of section, the sorting order of the whole numbers, blah, blah, blah. Okay. Reference to the California Constitution is also included in the table. Okay, the table of statute of regulations is current through Registry 97, number 52, December 26, 1997. That's when I copied this, or somewhere after that. The publisher recompiles the table of statute of regulations subject index for printing publication on a semi-annual basis. And there's other sections, which I don't see here, that says that this has it all. You know, this has all the sections that have regulations for them. So this thing has everything that would have a regulation to it. And it says if it doesn't have a regulation, they don't put it in there, because this is the California Code of Regulations, not statutes. So only if there are regulations, well, do they put the actual statute in here, showing you what statute that regulation attached to. Because there are no regulations that don't attach to any statute. They all attach to one statute or another. Okay, so if there's no regulation, means there's no statutes, means there's no regulations anywhere for it. So what we find is this section, which imposing a $500 penalty, has no enforcing regulations. They got a problem right there. The second problem they have is that if you do what the law says, which is to take the information off your federal return and put it on a state return, you can't put a different number there. Otherwise, you violate the law. So that's what you might call a catch-22, or they can't compel you to commit a crime so you don't have to commit a crime. That would void the statute at that point. So even if this thing had regulations, the fact that it requires you to commit a crime to be in compliance with the statute so you'll get penalized makes them void, because you can't have two statutes that one or the other, by obeying one you violate the other, by obeying that one you violate the first one, so you're always in violation in some way or another. Okay, so that voids both of them. So that takes care of that. No statute, there's no regulation. Now, the question, well, let me finish reading the letter here, because we just got to that. Section 19179 imposes the penalty of $500 shall be imposed for filing a frivolous return. The penalty is determined in accordance with what? California statutes, you think? No. Internal Revenue Code, Section 6702. Well, wait a minute. Isn't the federal laws for federal things and state laws for state things? Yeah, but except that California codes and statutes all depend upon federal to be implemented. So basically the Revenue and Taxation Code of California is merely the exceptions and differences from the federal law. The federal law applies except where they make changes. That's essentially how it works. Okay, so if you don't have any federal liability, you obviously wouldn't have a state. But anyway, the penalty is determined according to the Internal Revenue Code section 6702, which, by the way, what should you do when you read Internal Revenue Code 6702? You should look it up and look up the regulations, right? Which, by the way, it doesn't have any. What a surprise. It doesn't have any either. By the way, does anybody know what 6703 says in the Revenue and Taxation Code? This is a guess?
You mean the Internal Revenue Code?
Internal Revenue Code, yeah. 6702 says they impose a frivolous penalty if they determine that, you filed a frivolous return. They give you a couple of conditions, but they determine it. 6703 says something. Does anybody know what that might say? No. No hands? No? Shaking the heads, lowering the heads in shame and okay. Well, what 6703 says is that 6702, did I bring the, yeah, I did. Okay, great. I'll just read it rather than just do it from memory. Okay, 6707, there we go. Okay, 6702, here's what 6702 says. Frivolous income tax return, civil penalty. A civil penalty if, 1, any individual files what purports to be a return for the tax imposed by subtitle A, but which, A, does not contain information on which the substantial correctness of the self-assessment may be judged, or B, contains information that on its face indicates that self-assessment is substantially incorrect, and 2, so that means one of those two in addition to this, the conduct referred to in paragraph 1, that's filing the return, is due to A, a position which is frivolous, or B, a desire which appears on the purported return to delay or impede the administration of federal income tax laws. Then such individual shall pay a penalty of $500. Okay. Then it says B, penalty in addition to other penalties multiplied by B's in addition to other penalties provided by law. Okay, that's great. Now, 6703. Now, 6702 has no regulation, so don't really matter what it says. But 6703 is important because it says rules applicable to penalties under 6700, 6701, and 6702. Oh, that's the penalty they're trying to impose. What's it say? A, burden of proof. In the proceeding involving the issue of whether or not any person is liable for a penalty under 6700, 6701, 6702, the burden of proof with respect to such issue shall be on the Secretary. Oh, who? The Secretary, well, in case you didn't know, which you probably don't, but the Secretary, if it's used the Secretary, that means the Secretary or his delegate. You read 7701A, and you'll find out whenever they say Secretary, it means the Secretary or his delegate, which means that if somebody there is imposing a penalty, they got to be delegated the authority to do it, number one. Number two, the burden of proof is on them to show that you were in violation, and that means they got to have evidence, right? What evidence? How did they determine that? Perhaps you'd want to do a FOIA request and find out how they came to that determination. I think that'd be important. Okay. Okay, now, that takes care of that. Go back. Okay, 1602. As defined in Revenue Code IRC Code 6702, a purported return may be deemed frivolous if 1, which we already read this, does not contain information upon which the correctness of the tax may be judged, or the information on the face of the return indicates that self-assessment of tax is substantially incorrect, and 2, the conduct referred to herein is due to a position which is frivolous, which is pretty vague. I mean, what's frivolous? Or the desire which appears on the purported return to impede or delay the administration of federal income tax laws. Then such individual shall pay $500. The document you have submitted does not constitute a valid return as required by California personal income tax laws, specifically, let's see, Revenue and Taxation Code 18501. Now, 18501 does have regulations, okay? I don't know what they say, but it does have regulations. Section 18501 requires that a valid tax return be filed. Okay, a return form which does not contain any information relating to a taxpayer's income from which a tax is computed is not a return. Now it's interesting that they don't quote. Let's see, who was that? That was Long, the Long case, because the Long case, which is the 9th District case, says yes, it is a return. Zeros is a return. They didn't quote that. I wonder why. But they quoted the 10th District, which is not our district, saying that it's not a return. They said in the United States versus Proth, P-R-O-T-H, 10th District, 1970, 426, Fed 2nd, 519, certified, cert denied. That's a certiorari. They made a certiorari. It was denied. 400 U.S. 824, 27, blah, blah, blah. Okay. In other words, they quote one case, not the 9th Circuit. California's in the 9th Circuit. The one case in the 9th Circuit that talks about that is the Long case. In the Long case, the 9th Circuit said it's a valid return. Gosh, they're not trying to deceive us, are they? The financial information on the return form must include all taxable income from all sources. Compensation received in whatever form, including wages for services, constitute taxable income. Longsdale versus Commissioner. 5th Circuit. They can't seem to get the 9th Circuit. You notice that? That's because the 9th Circuit hasn't ruled the way they want to on these issues. And so they're going to other places. By the way, all other circuits other than 9th Circuits are merely advisatory to the 9th Circuit. They are not compelling. In other words, they don't compel and force the 9th Circuit to do what they ruled. It's only advisatory. Here, this is how we did it. You might want to do it the same way. You know, they can say sure. They can say no. Obviously, the 9th Circuit said no on the zero income tax returns. So, so they don't bother quoting our own circuit. They go somewhere else and try to find one, which has no bearing at all. Yeah.
Does the FTB have the same MO as the IRS in saying we don't accept the 9th Circuit's decision? The
No.
FTB has to accept
Well,
it.
see, 9th Circuit is federal.
Yeah.
California is technically, I mean, you have what the law is and you have reality, okay? The reality, all courts, federal, state, or whatever, are all under federal jurisdiction. I mean, that's reality. However, constitutionally, there's supposed to be a difference, and they have to impose that difference when they make a lot of these decisions, because then the reality that we have no states would come to roost too quickly on the American people, and they might start asking questions. So they do hold to the rules that states have their own rules, their own court system, and they give them their own names, even though they cannot do anything which would violate your individual rights, because that comes under the protection of the federal law. You know, that's what the federal government was there for, and to arbitrate the problems between citizens and the state government itself. Because who else do you go to? You go to the state courts to get a fair hearing on whether the state can do something to you? I don't think so, you know. That's why the federal courts are there, but at least that's what they were there for. But anyway, do you know, let's say that I didn't tell you about the Long case. How would you find out what the 9th Circuit did on this particular issue? Does anybody here know?
Go to the law library.
Would you go to the law library?
Well, other than kind of put your head against the books and hope something soaks in.
And try to get the site and then shepherdize it. See if
Okay, there you go. That's it. You would shepherdize the site. You would look up in Shepherds this reference, okay? The U.S. versus Proth, 10th Circuit, 1970, 426, Fed 2nd, 519. You look up that reference, okay? Because in Shepherds, it's going to tell you by circuit all the cases that have referred to this case, all the cases that disagree with this case, and all the cases that agree with this case, and all the cases that make any kind of mention of it in what way they had mentioned or said where our case is like that, our case is not like that. And they do it by district. So you can go down to the 9th district and find everywhere, every case that the 9th district has made reference to this case. And you'd see Long's in there. And you'd see that Long's, they would mark it with a code saying that Long's disagreed. Okay? They came to a different conclusion, which is, of course, why they didn't quote it.
What if they didn't publish it?
What didn't publish the case?
Such as Long's case, what if they didn't publish it?
Well, it probably wouldn't be there, but Long's is in there.
They did publish that one, so.
Yeah, and the point, though, is that, you know, you're not going to get cases that aren't published, you're not going to get it, but that is how you find out cases in your area that apply, when they're quoting stuff outside your area. When they start reaching outside their area, that tells you something right away. It tells you either this circuit has not ruled on that issue at all, which seems very unlikely, or this circuit has ruled on it, and it was a bad ruling for the writer of the letter, i.e. the state. So they race outside to some other circuit and quote them in hopes that you're just an ignorant layperson and you won't know to do these things, okay? To go look it up and shepherdize it and find out what our circuit said about it, which was that it was a valid return. So that's the thing you could send back to them. You know, excuse me, but I see that you quote the 10th Circuit, which is not binding upon us here in California since we're on the 9th, and the 9th Circuit said that it is a valid return. So are you telling us that you're superior to our federal courts and the federal government, that you get your laws and rules from? You say you get this penalty section in accordance to their rules, but you don't have to listen to their rulings on those rules? Is that what you're saying? I don't think it works that way. You can't have the cake and eat it too in that regard. But anyway, that's one way to deal with it. Now, it says the law requires a written declaration that the information submitted on the return be made under penalties of perjury. I didn't know if that was altered. Of course, I didn't look at it. Let's see. Well, important. Sign your return. No, you didn't alter this, right? Let's see. I am not signing this 1040 form voluntarily. Okay, actually you should put that above your signature, not below it. But anyway, you didn't alter the under penalty of perjury statement, correct?
I don't think I did.
Yeah, I didn't see any changes on there. But obviously this is a form letter, okay? Because a lot of people who do these things alter it and they shouldn't. Okay, the law requires a written declaration that the information submitted on the return be made under penalty of perjury. Does anybody know that code section? I mean, I quote it all the time. California Revenue Taxation Code, section 18. Anybody? 621. Okay. So 18621 says that any papers submitted to them under the requirements of the law have to be submitted under penalties of perjury, which means even the stuff they give to you. All right? So they're correct on that, and if you're sending them papers that's required to be given to them, if you're filing a return, you're saying there's a requirement there, then you have to sign that under penalty of perjury. So be in compliance with your own gripe to them.
Do they not also have to sign under
Sure.
penalty of perjury?
Yeah, they
by law?
do. They do, but they're required to, but they don't do it because they don't think you're gonna complain about it anyway. Okay, to alter the jurat, which you didn't do, or the space provided for the signature, claiming that the document is filed under penalty of perjury for a return, is an attempt to retract or qualify the jurat. Such qualification render the document invalid. Sloan versus Commissioner, 7th Circuit. I still haven't hit the 9th Circuit yet. 1995, 53 Fed 3rd, 799. The jurat in the signature block of the 540 may not be altered. Okay, yeah, you don't have to alter it. You just don't scribble anything out or anything. Just write whatever you want above your signature. But I usually, don't recommend people modify that anyway, because you are signing the penalty of perjury because you are believing what you are saying. That is that this is true. Now, how can you fill in this return then and not have them kick this back and send you this letter? Well, here's the way you do it, and it's quite simple. Don't put zeros on every single block they have on there, okay? You see right here on number 12, at least it's 12 for this year, which is 96, okay? But here on line 12, it says state wages from your Form W-2, box 17. Now, what he put in there was 0. Did you have a W-2 that year?
No.
96? Okay. Then you should just leave it blank. Did you have any income?
Yeah.
Or did you have 1099s or things like that?
1099. That's where they picked up that I had not filed.
Okay. Well, there's another, anyway, we won't get to that right now. For all you W-2 people, what you want to do is you want to say state wages from your Form W-2, box 17, and put it right in there, what's on that form. Because that box doesn't do anything. It's just a box with the information copied straight off your W-2. And it's there on your W-2, and if you don't copy it, if you can't copy it off your W-2 and stick it in here exactly like it says, then obviously you're up to something. Okay, because this box doesn't do anything other than hold the number that's in that W-2 box. That's all it does. So you copy it right on there, and it makes them real happy if they got a W-2. And then here on the next line 13, it says federal adjusted gross income from Form 1040, line 31, or Form 1040A, line 16. And that's where you put the 0, line 13, because your federal Form AGI is 0. So you'd want to put the proper number in here, and then put the 0 down here, and then skip all those others, put the 0 there, and on it goes. And whatever tax was held out, you know, put that down there. Then they'll send you your refund. Okay, but if you put this 0 on box 12 when you actually have a W-2 and have wages, then they're going to call it frivolous. Okay, so anyway, this way it'll get you your stuff. Now, if you have 1099s and stuff, of course, 1099s is the presumption of income, and there's lots of different ways to do that. One of the ways is, of course, the deductions and stuff that you have against that money. If you have enough deductions that you put down on the form so that it zeroes out, or you get to less than 400, so there's no Social Security, no Social Security tax at the federal level, then you're not going to have a tax anyway. And let's say that that after filing that form that you get an audit. Okay. Now, if you get an audit, generally it's not going to be from the state. It's going to be from the federal. They're the ones that audit you. The state just waits for the federal audit, and then they just get the numbers passed to them, and they don't have to pay for all those people to do all that work when the federal's doing it, and they then share the information, and then they assess you. So let's say that you're audited on the return, that you end up making almost no money at all. Well, what do? The best way, I think, at this time, this day and time, is to take the kinder, gentler approach with the IRS. That is, you want to show you have a cooperative spirit, because they're going to document any kind of hostility or anything else and call you some kind of a radical terrorist and dangerous taxpayer and things like this at any chance they get. That's why they I don't know if you've been into any of these audits and stuff where somebody gets a little heated or whatever, but that's why they ask you these questions. Are you threatening me? You know, is that a threat? You know, they're always asking the question. Is that a threat? You know, well, how are you today? Is that a threat? Oh, no, it's not a threat. I was just asking how you were today. You know, they're always asking. Yeah, that's a threat. I'm threatening you with the weather. But you know, they ask you these things because they'd like to document you as a dangerous taxpayer. And a dangerous taxpayer, they can call in the CID and have them stand around with their bulging sides so they can feel like they've got some real importance there. But you know, you don't want to get labeled like that, because then you don't get any cooperation at all, as though you got any anyway. But still, you want to be just kind of a person out there who looks like he's doing everything he's supposed to be doing, but they just never seem to get anywhere with. That's what you want to be, rather than somebody who's confrontational. And the best way to do that, in my opinion, is, let's say you get your audit letter, okay? You get your audit letter saying, hey, we want to look at your stuff. And you say, hey, it sounds great to me, got all my records, don't have a problem with that, I want to meet with you. However, you know, this code, I can't find in it where it says that you can audit my return. Therefore, when I get there, have available the code section and the enforcing regulations that show that you can audit my return. It says, and if it doesn't have your name in the code specifically that you can audit my return, then have your delegation of authority orders going from whoever it does name down to you so that I can see that you have the authority to audit my return. In addition, I don't know who you are. You might be the janitor, you might be a person who can receive my papers. I don't know this. But to make sure that I'm dealing with somebody that does work for the IRS and has authority and is a government employee, what I want to see from you is your oath of office. I want to see a signed copy of your oath of office that's been filed, and I want to see your fidelity surety bond. Now, they don't want to give you that stuff because that's in their real name. Okay, it's not in John Brown or their, what are the other ways? Ted Green,
Joe Gimme.
yeah, Joe Gimme, and Jane Tax-a-Lot, you know, yeah, all these other obviously phony names. Those are under real names, and they don't want to give that to you. So you get there, right? You send this letter, you tell them you're going to record it. I always bring a certified court stenographer because you want to make a record of what transpired. You want to show that you're cooperative, and they're not. You want to show that you've done everything that you could have possibly done to make this thing whiz right through, and they're the ones who are throwing up the roadblocks. If you ever have to go to court, you'll need this record. Okay? So you put this letter to them, you make sure you get it to them 10 days before the meeting. So if there's a meeting that's going to happen before, you can get them a letter before 10 days, let them know you're going to record and everything. Then you want to tell them, hey, listen, I can't make this meeting because I know I have to give you 10 days notice to let you know I'm going to record it. And I'm going to record it, and I know you need 10 days notice, that's your policy, therefore, you know, we need to extend this out a little way so I can give you some written notice that that's what I'm going to do. And they may waive the written notice, which is fine, but you still give them the written notice, okay, saying that they waived it. And then you ask these questions that you want this stuff. Now, you also put in your letter that if they are unable to provide this for you, that for them to bring with them somebody who does have these things, the oath of office, the delegation of authority, the fidelity surety bond, so that you can give them your records. Okay? So now when you get there, have you been the good citizen of the United States and done everything you did to properly inform them what's needed so they can have their records? Absolutely. Have you done that? Absolutely. Can you be labeled some wild-eyed radical tax protester? Absolutely not. Because you haven't said you're not going to give them your records, you told them you are. All you've asked them to do is to do what the law says they're required to do in the first place, which they never do. Okay? So all you're merely doing is just asking them to do that, to follow the law. You want to follow the law, you want them to follow the law. That's all you're asking. So when you get there, they're not going to have these things. Okay? If they did, it would be a first. First for me. And I've done this for 30 years. Okay?
Wow.
So it would be a first for me. So they're going to come, they're going to try to bully you. They're going to do one or two things when you get there. One is they're going to try to have the meeting out in the foyer as opposed to in the office. So I always keep my recorder with me, and as soon as they step out the door, I turn it on so I can get it from the beginning. And then if I have to give it to the certified court stenographer, she can, you know, complete the record that way. Many times, especially if I know the people I'm dealing with, I'll have the stenographer set up and ready to record as soon as they step out the door, because I know what's going to happen. So I might as well start making a record right there when we do. So anyway, that's one thing. So if you do, if they want to, what they'll do, by the way, when they step out there and start talking to you, they'll say, well, why don't you just give us the records right here, we'll take them in, we'll look at them, we'll write you and let you know what our decision is on this. And if they did something like that, your response would be, gee, I don't have a problem with that. Are we going to have the meeting right here in the foyer then? And they would say, well, no, we just want your records. And I say, well, did you get my letter? And you could start that conversation and go that way, or you could say, says, before I turn over my records, I want to sit down and discuss something with you. Says, let's go do that. Let's go. Let's have our meeting. And then if they insist on saying, no, we want to have these records, say, well, then are you denying me the meeting? Are you saying we're not going to have an audit meeting? Are you closing that down? We're not having it now? I've got my records here. You're telling me you don't want them now? They'll say, well, no, we want your records. Say, we don't do business out in the foyer. It says we either go in there, we sit down, and we have our business meeting, or we're not going to have a business meeting. Now, which one is it? Are you saying we are not going to have a business meeting, or are we saying we are? Now, what they try to do is they try to put it on you that you're not cooperating, okay? And what you have to do is put it on them that they're not cooperating. Because how many businesses do business out in the foyer on something as important as transferring records and things like this? You know, it doesn't happen except in underhanded things. And of course, IRS is underhanded. But we want to bring them above board, and we want to do this all across the table. So we insist that we have that meeting. We have it in there. And that's the only thing you want to talk about. You want to
be in control.
Yeah, they're going to try to take over control, and you're going to have to stand your ground, and you're going to have to be in control. Say, oh, I'm here. Says, I'm ready to turn over everything I need to turn over, but we need to sit down and have this meeting and go over a few things. They'll say, well, what a few things? Well, that's what we're having the meeting for. Let's sit down and go over it there. Okay? So they'll try to have this thing in there because they don't want a record made. When they don't want a record made, that's what they do. They sit out in the foyer and try to converse with you and get the whole thing shut down without, quote unquote, a record being made. Most of the time, it's the first time they don't know who you are, you're not going to run that problem. That's going to be, you know, maybe 2 or 3% of you run at the problem. The rest of you are really going to, this is what's going to happen. They're going to come out and say hi, you know, come on back, and say, oh, gee, you got so many people here. You know, that'd be you and the stenographer and preferably one witness. And you go into the back room, you sit down, and then you ask the questions. And the questions are, did you get my letter? They're going to want to ask you some things. Are you this? Do you still live here? Where do you bank? You know, no. We haven't got there yet, okay? Where we are is you sent a letter to my house. The letter is in all uppercase, and I don't really know if that's me. I really don't know who it is. I just know that it arrived at my house, and I hear you guys do horrible things to people when they don't respond to things you send out. Therefore, I came mostly out of fear that you were going to do something unlawful to me. And so that's why I'm here. Because I've seen the Senate things and I've heard the things that you guys do. And it says, and I'm afraid of you guys. I'm afraid that you guys really don't follow the law. Now, I might be wrong. You might be a nice person. I just don't know. But I'm here in that regards. And, you know, I guess if you follow the law, I'll be able to give you your records and we can get out of here. So you guys follow the law, don't you? That's what I asked. And, you know, and they'll say, oh, yeah, we follow the law, you follow the law. Or they'll say what? You think we're not constitutional, or you think that the Constitution doesn't allow this, or they'll try to make it some negative statement. In which case, well, if they make a negative statement, I'll say, well, I don't know. Is that true? Let them answer their own stupid negative statement. I don't answer it for them. So, yeah.
You still go sometimes too as counsel, right?
Sure.
Have you pretty well got them beat on that? Because I've heard the tapes where they try to get you to be quiet. And
yeah, well, yeah, that happened a long time ago. I haven't had them jump up and down and yell at me to tell me to shut up anymore. But that was fun. But you know, they've changed their tact in how they do things. And so at this point, when you go in there, you know, if you're calm, and if they do anything in any kind of emotional way, you should always read the emotion into the record. If they get excited, well, I don't think you should be doing that. It says, oh, well, calm down, calm down. You know, you need to say that so it's on the record, right? Calm down, calm down. You need some time. Looks like you're really getting upset here. You know, typing away, a little stop, oh, you're really getting upset here. You know, because who's ever reading the transcript, they don't know what's going on. They only read words. How do they know what emotion is being displayed? Because you say it. You say it and it goes on the record. That's how they know. And on a tape, of course, you can hear it. But on a transcript, which the court usually gets, there's no way to hear it. Therefore, you have to say it. So when they do something that's exciting, you know, or if they get excited, you need to tell them they're excited and ask them if they need some time to cool down, you know, because somebody's reading that. Do you need some time to cool down? No. Oh, okay. So that tells them something, yeah.
How many of your transcripts have actually ended up in court?
Well, so far I haven't had any. But you'll find it's like, you know, they say an ounce of prevention is worth a pound of cure. And if they know that you've got the goods on them, they're hardly likely to take this further. Because, you know, it just doesn't pay. When it shows that they're excited, they're not cooperating, they didn't bring forward the required records, they didn't bring forward the information the law says they're required to have, that you were willing to give your records, you wanted to cooperate. Hey, if they didn't have the information, then bring somebody else in so you can give them the records. I mean, you know, you're just the epitome of cooperation, and they're the epitome of obstruction. That's the way it appears on the record. Yeah.
Jim, in the letter that you sent to them after you received the initial letter, do you have the sites where they're required to do that by law? Is that part of the letter?
No, not normally. I may throw in a court case like the California Bank Association versus Schultz, where the Supreme Court stated that when you deal with some agency or an agent of an agency, that it is your duty to make sure that they have the authority to do what they purport to want to do. Well, all I'm doing is doing what the Supreme Court said. So are they superior to the Supreme Court, where they don't have to obey the dictates of the Supreme Court? I don't think so, because that's the final law of the land up there. Heck, they even make legislative policy. So they're everything. They just don't go out and enforce it. They leave it up to the executive branch. But they do everything up there. So they're not superior to them. And I've asked them a couple of times if they thought they were, because they said, we don't have to do that. And I said, well, oh, then you're superior to the Supreme Court of this country. So why do you say that? I said, because they said you had to do it, and you told me you didn't. So either you have to do it, according to the Supreme Court, or you're superior to them and you don't have to do what they tell you to do. Which one is it? You're being disruptive. Says, you're getting a little excited now. Would you like to calm down here? Says, I'm not getting excited. Says, would you like 5 minutes to, you know, kind of cool down, get a drink of water or something? Look, I don't want you to explode on me here. Okay. Yeah, let's make that record. So anyway, so when you get in there, they're not going to have the stuff. Okay, so you go into the meeting, they're going to try to quiz you on where your stuff is, where you live, all this kind of stuff. And I stop them right at the beginning and say, well, before we get to that, there's some other stuff we need to get to first. Did you get my letter? And they'll say, yeah, or they'll say, what letter? Says, well, the letter sent to you certified, and I received the certified mail back on such and such a date that asked for a few things so we could turn over the records to you. Did you get that letter? Now they say, yeah, we did, or no, we didn't. It's in their file. They got it. Okay. So if they didn't, I say, well, I have a copy of it right here. If they don't have it, most of the time they do. So I said, okay, well, as I said, we were going to ask for these things so that we could turn the records over to you. Now, I don't say we're going to ask for these things before we turn the records over to you. I said we're going to ask for these things so that we can turn the records over to you. It's a foregone conclusion that I was going to do it. I just have to find the person with authority to receive it. And that's what I'm there for. So they say, well, that doesn't apply to us. I said, really? Says, you mean there is no code section that allows you to audit returns? Say, well, yes, there is. I said, well, then where is it? Supreme Court is writing the letter, says that it's incumbent upon me to find out, and I told you in the letter that I looked and I couldn't find it. Where is that section? Sometimes they'll have it, sometimes they don't. If they have it in the supporting regulations, you'll see that it says the secretary can. Okay, so I say, well, are you the secretary? He says, no, the secretary means secretary of the delegate. Oh, okay. Then you're the delegate of the secretary. No, yes, I am. He says, well, then show me the delegation. Show me the delegation of authority orders then from the secretary down to you, showing me that you are his delegate. He says, you have those, don't you? Well, oh, we don't normally carry those with us. Says, well, I sent a letter to you telling you I was going to ask for it. Says, why are you so negligent in not preparing for this meeting? I prepared. How come you didn't? and then we'll get into the next subject. Well, listen, if you aren't prepared for this meeting and you're not ready to receive these records because you haven't shown that you have authority to receive it, so I can't give it to somebody who has no authority to receive it, bring somebody else in your office in who can provide the information so I can turn this over and we can get on with this. Well, there's nobody there. Nobody you can turn these things over to. And so they'll usually say, well, you know, we'll check into this and we'll get the delegation authority, or we'll get this, we'll get that, so then we'll get back with you. I said, well, you know, next time be prepared, because I spent this day coming down here and I'm paying this stenographer to record this thing, and it's costing me money. Now next time, and I ask you, because I usually put them in a letter, if they can't provide the information to let me know ahead of time, they're going to cancel the meeting and drop the audit. You know, they never do. So I said, now I asked you in the letter, in good faith, for you to let me know if you couldn't provide it. And you knew when I came here that you did not have the information and you had no intention of providing that to me. It says, next time, be prepared and don't cause me a damage by making me come down here and pay for these people when you had no intention of providing that which the law requires, so I could finish this thing and go on and do what I'm required to do in life. Chew them out, okay? Because it all goes on the record, right? And the judge reads that. And he says, yeah, these idiots, you know. And, you know, he's heard about the hearings as well. So that's the way I would approach the meeting. And, you know, usually you never get another notice to come back in. If they give you another notice, they may have the delegation of authority order. But now we got the fidelity surety bond issue, okay? Did they bring that? Because we need to know that they are a person who does work for the IRS. Their little badge and their little ID cards, those are insufficient. I can make a badge and I can make an ID card in a day, okay? So those things don't tell me anything. What tells me is what's been filed in the public record, because the clerks that file these documents in the public records and the insurance company that insure these people, they make sure that these people do work for the agency so subscribed. So all I want is a document that's a public document, the fidelity surety bond, that's a public document of that agent, his oath of office, that's a public document. I'm not asking for anything private. I just want to see that. It has a real name on it, so they're not hardly going to give it to you. So you're only asking for that which they're required by law to have available, if so requested.
And the reason they would be loath to give you the one that has their real name is because they, as an individual, would become subject to any.
Well, you'd know who they are now, right? You could sue them.
Delegation of authority orders, they blanket over that office, or do they go down and name names, or what?
Well, it comes from the secretary to the commissioner. The commissioner has one that goes out to all the regional offices, and the regional office will go down to the district office, and the district office goes down to the various branches, and the branches go down to certain ranks, like an E9 or something like that, okay? And so what you have to know is, what is he? You know, is he an E9, is he E6, an E7? You know, what is the guy? To find out, you know, but first you have to get the delegation order. That, you know, that in itself is a major work.
Well, is that the whole chain they would have to show?
Yeah, that's the whole chain going down. So, But those things are in books. I mean, it's not as though they don't get it and they can't get it. And it's a lot easier for them to get it than for you to get it. You have to do a FOIA request. And you can tell them, listen, if you want me to get the information, then let's postpone this thing for a couple of months, maybe about 6, for me to use the FOIA avenue to make the request for the delegation of authority orders, because that's about how long it takes for your agency to provide the information, sometimes up to a year. Now you can just go in there and get it, because you work here. It says, I'm trying to be cooperative and get this thing expedited, and if you want to get it expedited, then you ought to get the information. But if you don't want to get it expedited, and you want me to get this information, I'll do it. But you're going to have to give me 6 months to a year to be able to extract it out of your agency. Because all their delaying tactics and everything else, and the lawsuits have to be filed to get it. That's how long it takes. Now, what do you want to do? Do you want me to get it and you give me a 6 month to a year extension all this? Or would you like to do it? You know?
Have you ever gotten to stage 2 where they do come back with a delegation of authority and then you ask?
They've never done it with me. I have heard they've done it, somebody has done it with somebody. But they've never done it with me. But like I say, if they did the delegation of order, we now have the fidelity surety bond, the oath of office, and let's say they bring that, which I've never seen. But let's say they bring that because some agent actually used their real name. And so now the next question would be, what code section allows you, if you find anything in my records which are inconsistent with my return, what code section allows you to make a change on my return? I need the code section and the regulation. There is none, by the way. But I would ask the question, what code section says that you can make a change on my return? Well, if there is no code section, then why should I turn over information that they can't do anything with? There's no law that requires me to provide something that they have no authority to use for anything. Okay? So if they can't use it because there's no law that says they can make adjustments to your return, then there's no requirement to turn it over in the first place. So, and I forget the term that is called, but it's a term that means that if you have to turn something over and the law requires you to turn it over, but the person receiving it can't do anything with it, then the law requiring you to turn it over is null and void. In other words, you don't have to turn it over because you can't be compelled to do something when there's no reasonable purpose for doing it. Okay? And so that would be the reason you probably wouldn't have to turn over, because they couldn't provide any code section that says they could even adjust your return without your consent. And of course, I'd never consent.
Because they would be taking away your Fifth Amendment rights.
All right.
And they're always supposed to do things right.
Oh, yeah. They're always supposed to do things right. Yeah. Wouldn't that be nice if they actually did one thing right? So, okay. Anyway, that's how I would go through and handle a meeting with the IRS. The FTB is relatively the same. They use the Internal Revenue code sections, but they also have their own FTB sections. I would ask them the same question. I would go into any meeting with the FTB armed with this, okay? Armed with the Barclays Official California Code of Regulations. So, if they were able to provide any code sections, I would look up and see if there's any enforcing regulations. I would also go in there armed with this, which is out of the Internal Revenue, or the Revenue and Taxation Code, 19503. Now, 19503 says what? Rules and regulations. Maybe you think I was talking about under penalty of perjury is 18621. 19503 says you had to have rules and regulations. It says this. Excuse me. Franchise Tax Board shall prepare all rules and regulations necessary for the enforcement of Part 10. And in these things, up here, you'll see it has a part number, the little teeny thing. Okay? This is PT, that means part. This is 10.2. So the section that this 19503 is in part 10.2. So it says that, I'm going to break open this water. Okay. Small water. Okay. Now it says that they shall prescribe, that means write, all rules and regulations necessary for the enforcement of Part 10, commencing with 17001, which, by the way, is, I believe, the beginning of the Revenue and Taxation Code sections. Part 10.7, well, that's after Part 10.2, commencing with 21,001, Part 11, commencing with 23,001, and this part, 10.2. How about that? May be prescribed to the extent in which any ruling or regulation shall be applied without retroactive effect. So it says they shall, which means must, write all rules and regulations necessary for the enforcement of Part 10, Part 10.7, Part 11, and Part 10.2. By the way, the liens, the lien sections, the wage garnishment sections are all in 10.2 of the Revenue and Taxation Code. So they got to have it. Now, then I'd have that one, and I'd also have with them, let's see, do I have it in here? 18621. No, not there. 10.2. I was going to read that. 18621. Okay, I don't see it right here, but I do see it right here. 621, verification forms filing affects the failure to receive form, except as otherwise provided by the Franchise Tax Board and Section 18621.5, which just talks about electronic filing and stuff. Any return declaration, statement, or other document required to be made under any provision of Part 10, Part 11, and this part, which is Part 10.2, the same parts, okay? Any of those which are required to be made, or any return declaration, statement, or other document, that means anything, required to be made under any provision of 10, 11, and 10.2, which is this part, shall contain, which means must, or be verified by a written declaration that is made under the penalties of perjury. Okay, that's why you got to send your returns in under the penalties of perjury, because it tells you if you are doing something that the code requires you to do, you have to do that. That also means they have to do that, and they never do. Okay. So in dealing with the Franchise Tax Board, if I was going, I'd ask them the same questions. I'd ask them for their fidelity surety bond, their oath of office, the Revenue and Taxation Code section, the enforcing regulations that allow them to audit a return, and the delegation of authority order going down to them showing that they can receive information for this thing, that they have the authority to audit the return, in other words. Okay? So I do the identical same thing. Be Mr. Congenial. You're there to turn over some records, you know, and you're just waiting for somebody who has authority to receive it, because that's essentially what you're doing. You're trying to find somebody there who has authority to receive these records. And I don't know why, but nobody there ever has authority to receive records. But you're cooperating, you know, that's important. Now, let's see, what else? Did that kind of answer your question? Okay, good. What, we only spent, what, an hour and a half, huh? An hour? That's it? Answer one question? Okay, next one's a short one. Anybody got a short question? No?
Jim, is the IRS, I've heard some of the people say, and read some of them, that the IRS 1040 form and the FTB 540 are in essence like contracts? And yet,
Well, the problem with the question is, that's a short question, you can answer that one. The question is, are the 1040 and the 540 tax forms, are they like contracts? Yes and no. If they were a contract, it'd be one way, because a contract requires the signature of two people and only one person signing this thing. Okay? It's